Good morning, and thank you for joining us for the Winter 2023 Legal Landscape and Turfgrass webinar series. We're very pleased that our first webinar is with our good friends from Stanton Law, LLC, Elijah Davis and Evan Alberhasky, who will be talking about how to handle an EEOC complaint of discrimination. It's unfortunate that we are seeing more and more of these issues, so it's wonderful that they are here to take the time with us to do this. We want to thank our webinar series sponsor, who is the Georgia Certified Landscape Professional Program. Greg Huber from the University of Georgia handles this, is a wonderful, wonderful educator. So if you're not familiar with the program, please go to the UGAurbanag.com/certifications website and learn more about it. We also want to thank our annual seed sponsors who just help support us in every way beyond their membership. I know that a couple of the people participating on the webinar today are our sponsors, so we thank you for that. That's a really good commitment that we greatly appreciate. So I'd like to now let our speakers, Evan Alberhasky and Elijah Davis, start their presentation.
Thanks so much for having us here today. So we're going to be talking today about EEOC charges and what to expect. I hope that none of you ever have to deal with one of these, but it's certainly easier to navigate if you have a basic understanding of what to expect. And we'll be talking about not only what to expect during the charge, but some ways that you can help minimize the chances of having someone file a charge against you, as well as ways that you can set yourself up so that if a charge is filed, you have the types of documentation that would be necessary to defend against such a claim. So that's going to be the basic of the webinar. I'm very happy to be presenting with one of my coworkers, Evan Alberhasky. I'll let him introduce himself very briefly, and then we'll get right into the present. Well, then I'll introduce myself after him.
Hi, everybody. My name is Evan Alberhasky. I'm an associate with the firm. I've been here for almost 2 years. I started off as a clerk while in law school. I just graduated from Georgia State last year, back in May, and passed the bar in August. Primarily been working in traditional employment law areas, wage and hour issues, general counseling, compliance. And I also do a little work with business formation and corporate law and corporate transactions. So I'm excited to be here as well. And I'm currently involved in several different EEOC charge processes as we speak. And so hope to be able to bring some real world experience into this presentation. Thank you.
And my name is Elijah Davis. I've also been with Stanton Law for about 2 years. I'm as of January the 1st of this year, I'm a partner with the firm. It's a great law firm that I could probably spend the entire webinar talking about. But as far as my legal background goes, I have quite a bit of experience defending employers and insurance companies in workers' compensation claims, as well as a variety of employment discrimination claims. Evan previously mentioned that he's involved in some investigations with the EEOC. I am currently involved in some litigation after EEOC investigations. We'll talk a little bit more about that towards the end of the webinar in that section, but it is not at least the claim that I'm going to be discussing as an example, it's not a good, position to be in to go into litigation without the types of documents that would be most helpful to you. What are the objectives of equal employment opportunity laws? And I'm going to hand that off to Evan.
So EEOC, which stands for the Equal Employment Opportunity Commission, is the organization that is responsible for enforcing all the federal laws that make it illegal to discriminate against either a job applicant or an employee because of that person's inclusion in what's known as a protected class or protected category. And Elijah will probably cover what some of those are, but some of the common ones which we think of right away are race, religion, nationality, national origin, and age for those who are 40 and older. And most employers are covered, assuming they have at least 15 employees. And for age discrimination claims, you have to have at least 20 employees. So there are some threshold differences there. Most labor unions are covered by these laws. Most employment agencies are covered by these laws. And the laws apply to really all types of work situations, including hiring, firing, promotions, harassment, training, wages, benefits. So we're really talking about kind of a broad array of different employment areas where there could be discrimination. And the basic objectives of these EEO laws, and I'll just use EEO for short, just helps avoid any tongue twisters, really to remedy past discrimination. That's one of the major focuses, to prevent violations of future discrimination, really to ensure that employees are given an opportunity to compete fairly in the labor market for the positions for which they're qualified. Also to receive objective ratings based on their performance. And lastly, not to be subjected to any personnel decisions or unfair treatment based on any factors that are non-merit related. And really what that boils down to is we want to be able to make a decision on someone's employment based on their actual employment, not a particular factor that is what is known as one of these protected classes, not because of their race or their religion or their nationality or anything like that. And so the EEOC really has the authority federally, and it should be noted there are other state-based similar commissions, human rights commissions or civil rights commissions, which can do similar types of investigations on a state level. But the EEOC is the federal one, and that is kind of what we're going to be discussing today. They have the authority to investigate discriminations against employers who are covered by this law.
So one of the main kind of protection that many applicants, employees, and even former employees have is through the Title VII or through Title VII of the Civil Rights Act of 1964. So previously, Evan had mentioned a few categories, and to expand upon those, and I'll say some of them again, you've got race, color, religion, sex. As far as sex goes, that can include pregnancy discrimination, gender identity discrimination, sexual orientation discrimination. Then you have national origin, age being 40 or over, disability, and genetic information. And what Title VII is going to do is not only protect an employee from the actual discrimination, but it can also give them a claim for retaliation. So as a basic example, let's say you have someone that has carpal tunnel that is requesting to use a brace while they're working. And they ask to use a brace and you fire them for asking that. That could very easily be a situation in which they've requested an accommodation for their disability, which in that situation that I just gave, I would say that there may be some liability for not participating in the interactive process, but then terminating them for asking for such an accommodation could be considered retaliation. Other examples of retaliation would include filing a charge of discrimination. So if they are a current employee and they file a charge and you fire them, or let's say that someone else is involved in a lawsuit and you have an employee that testifies unfavorably for the company or towards the company, and then you fire that person. That could be potential discrimination. What I want to be clear of as we're talking through this, and because of the time that we have, we're not going to go over every possible basis that someone may have for discrimination. For example, we don't have a slide on the ADA because that would just make this a very long presentation, but Title VII is going to encompass what I think of as the majority of the claims that are going to be seen. In order to file a charge with the EEOC, you have to have the basis to file the charge, but also an issue. So think of this as a simple math equation that a complaint is basically a basis plus issue. So the basis would very likely be one of those categories that we just discussed. And then the issue would be some type of an adverse action that caused an injury. I don't mean physical injury. It could be a current harm that the person is experiencing. It could be that you took away a bonus that they were qualified to get. So what this looks like on a charge that may be filed by an employee could be something to the extent of, I believe I have been discriminated against based on my race because on this date, someone of a different race was promoted and they had no experience. I had a lot more experience than they did, but they were promoted because of their race. Now, I hesitate to say that it might always be a complaint from someone of a minority against someone of a majority being promoted, because what we are seeing more of in the past few years are claims of what is probably easiest or more easily described as reverse discrimination. So a situation in which a Caucasian male is filing a claim because an African-American female was promoted over him. So when I say race, it's any race. It could be, you could be in a majority Vietnamese neighborhood and someone of Chinese descent may be discriminated against and have a claim. Another example of how this could come across is let's say someone has been working with you for several years, presenting as male, and then comes to you and discloses that they are transgender and that they're going to start dressing in the opposite gendered clothing that they have been. That could easily create a situation in which, if you terminate them the first day they come to work, where they could allege discrimination based on sex. As we go through, more examples will come up, but these are some of the ones that I just wanted to point out. And I'm seeing that we have a question that came across. What is the threshold for making accommodations if the person cannot perform the job efficiently? I will talk about that later on, but that gets more into the reasonable accommodation discussion, which is possibly outside the presentation we're doing now. If we don't get to it, please feel free to reach out to me directly through our contact information, and we'll set up a time to cover that one-on-one. Before we get too much into the actual complaint process, I want to discuss a very important concept in dealing with your claims, and that is before there's ever a complaint filed, there's this great thing called an audit, right? An internal audit of your policies, your procedures, how you're handling things. This can be an audit generally of your organization. It can also be an audit of a particular situation, again, without a claim being filed, basically just realizing that the writing's on the wall and that you want to start addressing it beforehand. So I sum this up in, I don't know the origin of the phrase, but an ounce of prevention is worth a pound of cure. In Spanish, it's translated as it's better to prevent than lament. And I use this in just about every aspect of my life, where an audit can help you catch your mistakes. An independent third party, our firm, for example, your general counsel or a consultant, can come in and look at what you're doing and give you ideas of how to make corrections or revisions to what you're doing in order to protect yourself. This can be something that starts and quite frankly should start as far as processes go before the phase in which somebody works for you. And what I mean by that is if your application process is such that you are committing discrimination at the outset, then even if everyone you hire never complains about you, you could still have someone that complains that wasn't hired. And that is because they can say they were not hired because of some protected status. The other reason, which I alluded to earlier, and we'll discuss a little bit more later, that an audit is so helpful is that it can reduce your future discovery and litigation expense. So if you are getting the correct documentation from the beginning, whether a complaint is filed or not, every time in every situation that could lead to liability, then when the complaint is filed, you're not scrambling to recreate a record that's beneficial to you. You are just going to your file or your database or whatever system you use to maintain this information and collecting it. From a legal spend perspective, the clients that I work with multiple times that know what I am going to need, and they can start creating and maintaining those documents before the case ever gets to me. When it does get to me and they send me a packet with everything in it, I'm not chasing them down for additional information, hopefully, or if I am, it is very targeted information that they may not have realized I needed because maybe they weren't looking at it from a lawyer's perspective. But ultimately, having that and being able to say that this was maintained prior to the discrimination, I believe is going to be more favorable to the organization.
So I'm going to talk a bit now about the complaint process, and it's actually a fairly fluid process, and sometimes the stages that you'll see here can coincide. Sometimes you can get one and very quickly find yourself in the next one. And so we'll spend some time here, and Elijah, feel free to sort of step in as I'm going through this. The basic starting point of the complaint process is ultimately the complaint itself. As Elijah alluded to, you may not know that you're going to get a complaint until it actually arrives on your doorstep. You may also, just based on the interactions with a particular employee, you may have an idea that something's coming down the pipeline. One client that we're helping now, I think back in September, they had emailed us and said, we were anticipating a charge. We just wanted to make you aware. Nothing came. We kept following up. We touched base with the employer just to make sure that nothing had happened since. Every few weeks, we checked in with them. Finally, we got an email towards the end of December saying, okay, the time's here. The complaint and charge has just been filed. So sometimes you'll know that something's coming and you can try to prepare for it. But if you haven't implemented some of the beneficial practices that Elijah spoke about, you're really still not in a better place because you may not have documented the necessary stuff that you'll then need once the charge kicks off. And so you'll get, and Elijah, if you can go quickly for me to the actual charge document itself, you'll get what looks like this. This is the charge of discrimination document. This is the actual EEOC form. And you'll see that there are a lot of sections that the complainant will actually fill in. They can either determine whether they want to file through the EEOC itself. Sometimes it will be filed through the state organization, a comparable state organization if there is one. Often they get filed in both. And this is where you will pretty much first get the information about what sort of discrimination the employee is alleging. And you can see in the lower box, there are several of the protected classes that Elijah had mentioned. There's a spot where they can put when this started, whether it's continuing, and then really a description. Often the description could be anything as simple as a short paragraph. We've gotten some within the past year that have been 10 pages. And so it'll vary based on most likely the individual filing. Sometimes they are represented at that point already by an attorney, and so the attorney may help them write it. Other times they are pro se, and so you will just be able to tell from often even the language of the charge sort of description itself, whether somebody is writing it on their own behalf or whether someone has helped them. And so this is usually the first thing that will come to you, often via email, and you will get a notification saying, please log into the EEOC portal. Now, the portal is an online database where most of the charge information is tracked. For those who have used the portal before or may have ever encountered it, it's a pretty standard setup where it will include the contact information of your organization, the sort of representatives who are indicated as being kind of the go-to people for this charge. And it will also include who is going to be overseeing the charge. And that will be an EEOC investigator or an EEOC mediator. And Elijah, if you want to go back to the flow chart for me, please. So the EEOC in years past, I think maybe since 2015, 2017, they've really started to encourage mediation much more. And Elijah has, he mentioned to me the other day that really just mediation in general over the past decade or so has really picked up a lot of steam, and it's just encouraged as a starting point for any sort of adversarial action. And so often the EEOC will encourage mediation. They do offer a free mediation service through an EEOC mediator. There is no obligation. You don't have to choose to do it. Sometimes the complainant will opt to ask to do mediation. Sometimes the employer will see that as sort of saving them time and effort in trying to mediate up front instead of investigating. And often the employer may have already conducted some sort of internal EEOC-like investigation themselves. We do have more sophisticated clients that have a larger HR team, and if they think that there's an incident that would potentially lead to an EEOC charge, some of them have gone ahead and conducted the internal investigation before the charge is even filed. And so you see a lot of different ways of handling this type of action. And it really just depends on how your business is set up, how much effort and what that translates to. It's to some extent expense you would like to put out before you actually get a charge. But what you'll see is that the further down this chart you go, from red to yellow, from green to yellow to red, the further down you go, the more cost there is going to be associated with each stage. At the mediation level, as I mentioned before, the EEOC offers free mediation. So you are probably paying mostly just for your attorney's fees to help you if you want to have attorneys present there. That typically will entail anywhere from an hour to a 3-hour session. It's done mostly virtually now. Some mediators do still offer in-person mediation, but it will start, you'll have an in-person a dual session caucus with both parties. You can offer to do sort of opening statements, but it's a very laid back atmosphere versus what you might think of being in a courtroom opening statements. Then the mediator will basically spend time with each side, trying to encourage them to reach a settlement. It can last an hour, it can last several hours, sometimes it can go longer. They can be rescheduled to have additional mediation sessions. The reason that you want to mediate at the beginning is because if you have to go into the next stage, which is the investigation stage, you are just going to open yourself up to more cost, more time, and it does turn into a bit more of a formal, although still informal. It's more of a formal process, because once the investigation turns to that stage in the EEOC portal, you are going to be requested to provide what is known as a position statement or a statement of position. And that is the EEOC basically telling you, please provide us with your side of the story. And to do that correctly, you are going to need to set up witness interviews with anyone who might have knowledge of the facts. And as you can imagine, depending on the type of adverse action that might have been taken and the particular incident that took place, there could be many witnesses. And you never know where an investigation may lead. We had a dual charge that came recently for one of our clients, and it started off as a discrimination based on national origin claim. And what we ultimately found through our investigation was that there might have been collusion on the part of those making the charge, when in fact they were discriminating against the person they claimed discriminated against them. And so you really just never know where an investigation can go. And once you open yourself up to going down that path, you really do need to walk it carefully and to do it thoroughly. Now, depending on the amount of time that your either state allows or the EEOC, you are given a certain amount of time to produce the position statement. You can get extensions. We tend to draft ours pretty formally, but with an eye towards the reader being the investigator themselves. They're not a lawyer typically, and so it's really just a 5 to 7 page document outlining the facts that we have uncovered through our investigation and our interviews, and then a legal analysis where you're basically trying to refute the arguments and the allegations that the complainant has made. Sometimes that's easier said than done, and it really just depends to a large degree on how much documentation there is that you've compiled prior to the incident. And that's why, what Elijah has suggested and that he may touch upon a bit more, it's really important to document, because it's so hard to counter someone's allegation if you have no documentation or evidence to counter it. And so if someone is making a complaint about a performance issue, if you have a performance review that you've given to them and discussed, if you have email documentation, if you have policies in place, you can use all of that as evidence in the investigation process and in the position statement. And that will position you much better for what is sort of the next step, is the agency issuing a final determination. Now, sort of anywhere along this continuum, the EEOC can immediately go straight to issuing a notice of right to sue. We had one charge, and it happened to be one of these reverse discrimination charges that Elijah mentioned. It was about a white male alleging discrimination by an African-American female supervisor. We never even got to the point where we had to write a position statement. The charge was just in the portal, and then we kept checking on it. Finally, we got a notice that the EEOC had simply just issued a notice of right to sue. And what that means is that the EEOC is not really going to investigate this anymore. They are just putting it back on the complainant to go to the actual court system to try to pursue this. And so That can happen almost anywhere in this process. It typically doesn't happen so early in the timeline, but it more often happens somewhere in the investigation stage, and they can issue a final determination, either finding cause on your part that maybe there was some discrimination by the employer. And in that case, they will request that you try to settle it. Otherwise, they can review your position statement and the evidence that you've included, and they can find a no cause finding and simply dismiss. And at that point, unless the EEOC comes back and issues a notice of right to sue, they're more or less saying that they have not found discrimination to have occurred. So that's really where the investigation stage would come to an end. And finally, you'd enter, potentially into the adjudication stage. The EEOC itself can actually bring suit, and that would likely happen if in the investigation stage they found so much evidence that the employer did discriminate. They have the authority to bring a claim against the employer, and so you can see that. And unfortunately, if that is the case, you are definitely, as an employer, finding yourself in an unfortunate spot. If the EEOC has brought a case and claim against you, it's likely because you've done something wrong. And as I mentioned, if you're at that point in the red spot, you're going to be incurring significant legal expenses, potentially tens of thousands, if not hundreds of thousands of dollars to try to defend it. Ultimately, at the end are the potential appeals and moving it into the civil realm, where the complainant could bring a case in state court or whatnot. And so that's the complaint process in a nutshell. The vast majority don't get to the adjudication stage. Most of them are either mediated or in the investigation stage. A settlement is reached. A settlement can really be reached at almost any time. That's why the mediation piece is fluid and it can come and go. When you do decide to mediate, your position statement is sort of put on hold. And so you have weeks or so to try to schedule the mediation and to have that take place. So it's definitely in your best interest as an employer to stay closer to the green and not get closer to the red. That will save you money and time for sure.
So we've talked about the charge process. I'd previously mentioned an audit from a preventative standpoint, but now we're looking at, so this slide is kind of the place that you would find yourself hopefully after an audit. But if you don't do an audit and you just go straight to some preventative measures, these are some things you can do to try and avoid an EEOC charge. One of the ones that, we get, or at least I have gotten a lot of pushback from some of my clients on this, but it's just simply an easy way to paper a file and kind of prevent some of these issues is to use what's thought of as a performance improvement plan, or a PIP, PIP. Some of my clients call it a performance improvement form, PIF. But what this essentially is a notation to the employee's file as to what they've done if they are the ones that are doing bad stuff. So as an example, let's say one of your requirements is to, and let's, for the purpose of our discussion, assume that this is an essential function of the job, right? That you require your employees to be at work at the beginning of their shift. So if you have an employee that is habitually 20 minutes late and you just allow it, never discipline the person, and then all of a sudden, you tell them that they have to be at work on time, or you fire them for coming in late, they're probably going to say, well, you've always allowed this. You never made me be at work on time. Now, taking that same scenario in which, let's say they come to work late, you give them a verbal warning, they're late again, and you give them a written warning that says, Bob, you were late 20 minutes this day. You have to be at work on time. We're going to put you on probation, or, this is just a written warning, and we're not going to do probation. But if you come in late again in the next 6 months or 12 months, then, the next phase might be termination. Doing something like that and sticking to it, this is kind of an empty defense if you are writing out 100 forms but never actually firing the person, right? If they keep coming in late and you keep giving them a form that says you're going to fire them but you never fire them, well, now the form's starting to look a little less like an actual performance improvement plan and a little bit more like maybe you're manufacturing a defense that's not legitimate. That goes to the general preventative measure of just documenting everything. Now, I previously just now mentioned a performance improvement plan, but even if you're not doing something that is that official or that documented, you could send an email to yourself that says, Bob came in late today, so that when you look back at your emails or your records, you have the dates and the times, and you're not just pulling stuff, out of your head or thin air. The next part that I want to talk about that I think will slightly tie into the question we had about accommodations is, one great way from a disability discrimination standpoint to avoid an EEOC charge is to make a good faith effort to participate in what's called the interactive process. So what that means is if you have an employee that comes to you and asks for an accommodation, that you don't just say no. Now, you can say yes, that it's okay to just say yes, but you can't just say no. And that doesn't mean you can't ultimately say no, but no should probably not be the first answer. To give an example of how this plays out, I have a charge right now where the job requires the person to be in an office, physically in the office, to talk with other humans, face to face. This is not a remote work possible position. The employee requested a reasonable accommodation of 100% remote work. Well, that doesn't work for this job, but the employer would, at least if they're my client, would not be well advised to just say no. What I would probably advise them to do if they got something like that would be to send, a copy of the job description to the person that's making the medical opinion, and asking if the employee is able to complete the essential functions of the job. So in the example that I just gave you, one of the reasons that was not necessary in the exact situation I'm talking about is because when the employee asked for the accommodation, they provided a medical note from their provider. I won't get into all of it because I want to, protect some privacy, but having looked at that note, I would have probably felt okay asking my client or advising my client that they could, refuse that request. But it is always helpful to just go one extra step and make sure, clarify that there's not some way to accommodate that. And what I want to touch on, and then hopefully when we get to the question and answer section, if there's more questions about this, we can discuss it just a little bit more. But with a disability accommodation, what's important to remember is that the employee has to be able to still perform their job with or without a reasonable accommodation. If a reasonable accommodation would cause an undue hardship on the company, then you may not have to provide that accommodation. An undue hardship could be something that's too costly for the company. It could be something that is disruptive to the company, something that would fundamentally alter the nature of the business. Some of the things that should be considered when you're looking at an undue hardship is it's not just the cost. It could be the size of the employer, the financial resources, the nature of the operation. And in a situation, just to make this a bit more nuanced and exemplify why it's very important to talk with legal counsel if you start to get into a situation like this, let's say that the business cannot afford the reasonable accommodation. That, again, is not an automatic, go to no. It's still, as part of this interactive process, would likely require the employer to see if there is some third-party source of funding, so nonprofit, federal, state, vocational organization, and it could also require the employer to offer the employee to cover the cost of the accommodation. Now, a lot of employers are not going to be in a situation where that's feasible, because if it's too much for the employer, it's probably also too costly for the employee. But there are plenty of employees that have independent wealth separate from their career and can fund an accommodation for themselves in order to be able to perform the job with a reasonable accommodation. If you have an employee that comes to you and says, I'm going to cover 100% of my reasonable accommodation, and it doesn't otherwise classify as an undue hardship, you're likely going to need, you would need, unless you want to hire us to defend you, would probably have to allow that. So I'm realizing we're short on time. I'm going to skip ahead just a little bit, and then I think if there's any questions, we can wrap this up. We talked about what to expect during the process. We covered the charge. And then after the EEOC decision, this is where if an audit or preventative measures or defense of the claim, none of these are effective, and you've got a bad decision, as a company, you're gonna have to deal with that decision. But you should also look at it as to how you can correct your policy so that in the future, you are less likely to be liable for a claim of discrimination. Now we're gonna get to the question and clarification section.
Elijah, can I make one point there on that last slide? Sure. So even before, and one thing I should have mentioned, even before the EEOC has made their decision, but as you're doing any of the mediation or investigation, if you think that you're going to come to an impasse and you ultimately think that maybe you have done something wrong or maybe you haven't, but you're afraid of what the outcome may be, it's always important to think about this as a business decision and to think about the potential for settlement and to look down towards the future and think what it might cost you should it go to litigation versus how much you might be willing to pay to, for lack of a better term, make it go away. There are often baseless claims of discrimination that will come up, but what you might find is that it might cost you more to try to investigate it than it would to offer a $5,000 settlement, and the employee might sign a full release. And so that's always something that you should be considering leading up to the decision, after the decision as well, especially if it's been found in your favor, but there's still a notice of right to sue, you may still want to try to reach a settlement agreement because it could be in your best interest as a business decision to expend some money up front to save some money in the future.
Yes, that is absolutely a great point to make, and I'm sorry I didn't focus more on that. But one thing about our firm that is different from a lot of firms is that we are trying to find business solutions to minimize legal problems. Now, our focus on a business solution does allow us to look at a claim separate from who's right or wrong. I have clients who are absolutely in the wrong, but it doesn't mean that the claimant is entirely correct. And my point there is, I have clients that have done things that they shouldn't have done, but looking at it from a business decision, I can go to my client, and in fact, I just settled a claim this morning where I had a conversation with the client and I said, you're going to pay me probably somewhere between $40,000 and $50,000 to litigate this, or we could likely settle it for $15,000. So even if we assume that my client is absolutely in the right, and for this situation, my client was, they had done everything perfectly. I mean, they are the ideal client because when they came to me, every single thing that they provided me, I looked at it and I thought, you have no liability, you have no liability, you have no liability. But even with zero liability towards the plaintiff or the claimant, they still have liability from the perspective of legal spend or legal fees. And so one of the things that we talk about at the firm is that it's probably never going to be cheaper to settle a claim than it is today, right? If you can settle it for a low amount today, it's going to possibly go up if you don't settle it. It doesn't mean you're going to settle it for more, but you might pay me more in legal funds. Another thing we generally tell our clients is, anecdotally, at least with our clients, you're not very likely to regret settling a claim. You are probably more likely to regret not settling a claim, particularly when the legal bills start coming in, and then you may still have an amount that is owed to the claimant at the end if you're wrong. So at all times, I think that it's beneficial for the company to look at this as a business decision and not just whether they are right or wrong from a legal perspective. I'm going to show you all a nice photo of the folks at our firm. Evan's over there on the right. I am on the left behind Foz. These are all the folks that work for us. Our firm is an entrepreneurial firm. Even though we are a law firm, we operate very much in a sense that all of our attorneys kind of run their own practice within an umbrella of a cohesive firm. And what that means is, Quentin is going to do some stuff with David Adams, like mergers and acquisitions that I don't do. But if you come to me, I can connect you with them. As a firm, we serve you holistically and try to look at your business goals and not just the litigation that you're dealing with at the time. I'm going to go back to questions and clarifications. If anybody wants to, I don't know if we can unmute folks or not. Until I find out, we have one in the chat that does employment. So does EPLI, Employment Practices Liability Insurance, help with any legal and settlement expenses? If you have EPLI, absolutely notify your carrier. If it is included in your policy, so my qualifying statement is, I don't want to say it's going to be included because these insurers will find a lot of ways to carve stuff out that you think is covered. But in general, if you have EPLI insurance and you haven't done anything that would exclude coverage, then yes, EPLI may pay for defense as well as settlement expenses. Now, most of my experience has been in workers' comp defense with workers' comp insurance. But in that situation, the insurance carrier would pay both my hourly rate as well as the settlement amount if it's approved by the insurance carrier. I personally do not do much insurance defense anymore. I have found, for me personally, that my professional life is a little bit lower stress when I'm representing the employer directly. So almost all of my clients are either uninsured or they have engaged me to represent the company directly and basically not monitor the insurance attorney so much, but kind of serve as an intermediary where I can talk with the insurance attorney, translate the legal into common speak, and then talk to my client about it. But ultimately, yes, if you have EPLI, you should notify the carrier if you have a charge against you. Did I hear somebody asking a question?
Yeah, and please feel free to unmute yourself if you have a question.
And then for the question about the threshold for making accommodations if the person cannot perform the job efficiently, I hope that I answered that. But the summary there is that if they can do the job with or without a reasonable accommodation, you should engage in that discussion. And if it would cause an undue hardship for the company, then you may not have to offer an accommodation. But before you were to finalize that decision, I would implore you to speak with your in-house or outside counsel.
Yeah, I mean, that was basically probably more of a workman's comp question after I thought about it, because, people requesting light duty and stuff like that, sometimes light duty doesn't exist.
Yeah. So I don't want to, I'm sorry, I will let you finish, but I do have an answer to that.
No, I'm finished. I mean, that's just what I was saying. Sometimes when the doctor or the physician requests that they be on light duty, it just doesn't exist. And we don't have a way to provide that for them. It's costing us more to try to figure out some new job for them.
Right. That is an amazing example of, again, why legal counsel should probably be consulted sometimes, but workers' comp is really my bread and butter. In an example where a doctor has provided light duty job, and I don't want to derail the presentation and switch it over to workers' comp. I'll make this quick and then we can touch base with anyone that wants to discuss it more. But if a doctor has given light duty restrictions, at least in Georgia, remember that workers' comp is a no-fault system. So if you can't accommodate the job, then they're entitled to the benefits under the Workers' Comp Act. But what I would suggest for one of my clients, I'm not suggesting it for any of you because I don't represent any of you, but historically for my clients, I would suggest having something called a 240A. The form name is WC-240a. You can look it up on the State Board of Workers' Compensation's website. And what this does is it is essentially a 2 to 3 page form where the medical provider goes through and actually, circles or answers a multitude of questions about what the employee is able to do. If you are not able to offer that position from a workers' comp perspective, then the employee would likely get what's called TTD, temporary total disability. Where it gets interesting and where I think you should have the conversation with your legal counsel is that the employee may also ask for a reasonable accommodation in order to complete those light duty job. So the reason it can complicate it is you may have no liability other than the statutory liability under a workers' comp scheme, while also having some liability under ADA if you just say, look, we can't offer this job, right? And that's where it's important to see the interaction. Another thing that is much more important here in Georgia now, since the 11th Circuit has issued an opinion in the last 18 months, or it actually might be 2 years now, is that if you have an employee that comes back from workers' comp, So you have an example in which the doctor or the physician or the authorized treating physician has released the employee to work with or without light duty. The employee comes back, but then they request FMLA leave to get to a point where they can perform the job without restrictions. If they're eligible for that, you still have to look at FMLA separate from workers' comp, separate from ADA. And the example that went through the 11th Circuit was someone who was released to work, went back. The employer required them to do a functions and a job duties test. They did not pass that test, so the employer made an adverse employment decision and did not provide the appropriate FMLA leave that the employee said would have enabled them to be able to return back to work. So we have another presentation that we can do sometime we call it the Bermuda Triangle. It's the interaction of workers' comp, ADA, and FMLA. But that is a web of different decisions that need to be made and should, I think, really be made in tandem and not completely separate. So you have to consider each request separate from the other one, but you also have to see how they interplay with each other. That was a long answer, my apologies.
Elijah and Evan, we actually, Todd Stanton gave that presentation in person a few years ago. Then I believe 2 years ago we did have that presentation in a web, but I think it'd be a great idea because the whole FMLA, scary stuff. So it is hard to understand. I hope that all of the companies who are members of our association have employee handbooks and have them updated. Is this something that they should include or have language in an employee handbook for the staff?
Yes, I think so. What I can try to do, why don't I see if I can get maybe either a pricing sheet or some type of something that we can offer your members if they do want to do an employee handbook. But we have quite extensive employee handbooks for different states, including Georgia. In that handbook, what I would recommend is that there be a policy that tells the employee what their obligations are in relation to these different types of laws, and then have an acknowledgement from the employee that they've received it. And so a very simple example would be to have an ADA policy or a reasonable accommodation policy that says something like, the company takes its federal obligations seriously. If you need, this is all shortened, please don't put these words in your handbook, contact me. But if you need an accommodation, contact this person in this department, or go to this website for our accommodation form and submit it to your supervisor. The reason I say don't put down what I'm saying is because depending on your organization and how it's set up, you may want to change that slightly, right? You may want to have one person in your HR department that gets everything. That's incredibly easy if you have, 20 or 30 employees. If you have 500 or 600 employees, you may want the request to go directly to, certain managers or division, managers, and then they can either approve it or send it up. And what I would probably suggest in a situation like that, if you are a company that is going to empower some individuals in your organization to accommodate requests, that maybe you say you can accommodate any request, but you can only decline a request if you've escalated it and had 1 or 2 levels of review. So we can customize that based on the size and the needs of the organization, but absolutely I recommend having this stuff in your handbook so that you can say from day one, or at least from the day one of creating the handbook, if you're doing it as an existing company, that you let all of your employees know how to request an accommodation. The one caveat I want to make there is that, remember, you may have to actually make a reasonable accommodation to someone that wants to make a reasonable accommodation. And I know that was a lot of kind of words that sounded like the same thing, but if you have your policy that employees have to go to a website to download a form, but that website itself is not accessible. So, let's say you have a blind employee, but the website is not such that it has a screen reader available, then you may have to make an accommodation for that person to request an accommodation. So these are all conversations that I would hope that we would have, as counsel and client. If I was representing you, if you have a separate attorney, it's the type of stuff you should talk to them about as well.
Well, this is terrific information, Elijah and Evan. Thank you so much. We have an insurance partner, Stellings Walters, that is, we've been working with them for many, many years, and they know the landscape industry. And I would recommend, if you're looking for insurance or considering changing, consider speaking with them. They, as I said, they know the industry and they know what your needs are. If you have any questions, or be sure to contact Elijah and Evan directly at Stanton Law LLC. We appreciate working with y'all. We've had a great relationship for a couple of years. For now, thank you, and we'll see you soon.